Hello and welcome to Inside Employment, a podcast series covering key developments and issues facing employees in Australia. My name is Lucy Boyd. I'm an executive counsel in our employment team here in Melbourne. I'm joined by two colleagues today, Natalie Gaspar, partner in our employment teams, and Melissa Gladstone, a partner in our disputes team from Sydney. On today's podcast, we're going to be covering one of the fastest growing areas of litigation risk for employers in Australia, and that's employment class actions. We'll be covering the trends, the mechanics, the economics, and most importantly, what employers can be doing right now.
Thanks, Lisa. It's so great to be joined and Mel to have your expertise in this issue. I was completely shocked, but not so on reflection. Employment-related class actions are the fastest type of growing class actions in Australia. So beyond shareholder class actions, product liability class actions. So it's very topical that the three of us are on the couch today to talk about the emergence of this and why so. Well, I suppose the why so makes sense, doesn't it, Mel? Because traditionally, employment-related claims and the activation of those claims on a group level has been the purview exclusively of the union movement in this country in conjunction with regulators. So if you think about, underpayment claims or any sort of claims of a contravention of a particular clause in an enterprise agreement or a contravention of a clause of a modern award or any of those sorts of claims, it's been unions, hasn't it? And have done so really effectively. But now we've got this new-ish entrant into the market, and certainly that trend is not retreating. In fact, it's increasing. So as it stands today, there's currently 47 employment and IR class actions listed in the Federal Court of Australia website, and those companies range across industries, don't they? So we've got retailers, we've got miners, we've got government bodies, and the nature of those claims really range from contravention of an employment instrument, so an industrial award or an enterprise agreement, or in relation to discrimination claims or human rights claims and the like. So, it's just
It's super fascinating for us as employment practitioners, isn't it? Because it brings in all these new players that we're not familiar with. Usually we're used to dealing with unions or employee advocates, but now, we're dealing with funders and plaintiff law firms. So it's, and different, tribunals. We're used to dealing with tribunals like the Fair Work Commission and the Human Rights Commission, and now we're in a whole different regime in the federal court.
So Mel, why we're in this space in employment? Can you give us a bit of an overview and our listeners?
And so I thought maybe the useful starting point is to just talk about the general class action landscape and why there maybe has been this shift from it being through unions or regulators through to now being an area that's being pursued by through the courts with plaintiff firms and often with the support of litigation funders. So many of our listeners might know this, but really outside the US, Australia is the next most fertile ground for class actions. And that's not because we're necessarily more litigious by nature.
No.
But what we do have here at the moment is a very, what I call plaintiff-friendly environment that's probably partly two things are driving that. So the first one is, I suppose, what I'll call the structure of how a class action is commenced. And there's a really low threshold for commencement. We can talk a bit more about that, but really you need, 7 or more people who have kind of similar or related circumstances and only one common issue of fact or law before they bring their claim. There's not a lot of procedural hoops to jump through at the outset. The second part, I suppose, which creates this kind of rich environment for looking for claims is the fact that there's so many different funding models available, and so the economics that are behind the scenes driving this kind of boom. And so you've got litigation funders, third-party litigation funding has been part of the Australian class action landscape for many years now. In Victoria here, we've got contingency fees. It's the only jurisdiction currently where you can get this kind of uplift. However, just as recently as a week or two ago, the Attorney General said she was open to considering contingency fees at the federal level, which is only going to increase, the economics that are driving these class actions.
i.e. the attractiveness of these sorts of claims for lead plaintiffs and litigation funders and plaintiffs.
That's right. We're looking to pursue it through this kind of contingency fee model where there are costs and a slight uplift on running the case. There's also no win, no fee arrangements. So there's lots of options for how to get these vehicles into the court and how to fund them when they're there. And there's lots that's been said over many years now, including we were talking a bit about various times there's been reform discussions and inquiries into the class action framework. There's been lots of ink spilled around, the percentages that return to group members versus the percentages that return to the promoters. And so we might touch on that again later. I think the only other thing I wanted to touch on in terms of why is that there's so many plaintiff law firms that are in the market at the moment. So many people will be familiar with what I'll call the big household names. So the Morris Blackburns, the Shines, the Slater and Gordons. We're not seeing them so much in what I'll call the employment class action space. But what we do have a lot of smaller or new entrants into the market, and there's many, many of them. And so when you look through the list of who is representing those kind of 47 cases on foot, there's a lot of firms that have, 3 or 4, but then lots that have 1 or 2, right? So there's a lot of activity in the market, and the firms are all looking to find new claims to bring. So it's quite entrepreneurial.
Yes.
And so I think that as well is perhaps driving into why we're seeing employment issues suddenly being an issue that's being litigated in this way. And I think it is because of the whole mix of things I've just described, but it's a competitive entrepreneurial environment where at least our view is that the promoters of the class actions are actively looking for new avenues for bringing claims.
It's interesting when you think that, we'll often come across plaintiff law firms like Morris Blackburn, Slaters like that, who have, well-established employment departments, but it seems like the trend here is for newcomers to the market, which don't necessarily come with that expertise.
Well, it's in competition with the union movement.
That's
Direct
right,
competition with everything that the union movement stands for, where there's advocating for employees' rights. You pay a membership fee, but they don't take a clip of the ticket of whatever compensation flows from that. So there is competition in the market, and I think what you're describing is this reality that it's business. It's a business model. It's absolutely a business model.
And it's bringing in these funders, but it's purely for economic gain. It's a business.
That's right. And I suppose, again, if you're looking for where are there new areas to explore, there's been a slight downtick in the shareholder space, and whether that's probably a combination of factors, but certainly defendants were having a really good run for a long time defending those cases, whether that perhaps had been putting off some of the promoters into exploring those cases more. Again, we might see a shift there now. We've had a couple of recent decisions through the federal court where the plaintiffs have been successful. But again, if we're looking for new avenues, you think, well, employment issues, this is going to arise for potentially anyone who has an employee, right? Or a number of employees. Yeah. And so you think, well, that is really any company, any organisation, government. And so I suppose the scope or the pool of potential issues that you're dealing with there is a big pool of potential cases where I suppose if you compare the shareholder context, that's limited to the listed organisations. Here we're looking at anyone who has employees. Similar to there was a lot of talk about the rise in data and cyber breach type class actions. Similarly, anyone who's holding consumer or employee data is at risk there, but we haven't seen that boom really kick off because there's not really a clear pathway yet to establishing how those issues might attract any actual loss or damage for the group members. Yep. That's not the issue here with employees. Yeah. So it's not really surprising, as you said at the start, Nat, that this has been a bit of a boom area.
Yeah, absolutely. And particularly if, listeners to our Inside IR podcast and certainly on this, we're in an environment where there's so much complexity in awards. There's you need an advanced degree in maths and computer science and everything to figure out how to pay people properly, often where there's ambiguity. And, so there's this ripe area, I suppose, where there is increased awareness by employees. There's rightly so, I might say, about their rights and entitlements. But just picking up on one point that you made, Mel, now class actions are available for group of employees where there's a common issue of fact or law. Now, that's a relatively low bar in an employment context. So all that is required is, there might be an issue of law as to an interpretation of a particular clause in an enterprise agreement or a modern award, or a particular fact base in relation to certain things, but that's it. It does not require the level of specificity, required. And all of a sudden, we're in this regime where it is a very different and tightly controlled supervisory role that the court plays in relation to these sorts of proceedings. And for those of you that have not been involved in this, there is, and I invite you, Mel, to share with us what those sort of avenues are, because it is a highly restrictive and very different type of litigation to the traditional types of underpayment litigation, sexual harassment litigation, discrimination litigation.
Yeah, I completely agree, Nat, and there's certainly discussion to be had about if this is going to be the best vehicle for employees to get the remedies. But perhaps before we get too deep into all that, Mel, maybe you could just take a step back and give us the one-on-one on class actions.
So, look, the class action specialists, we like to say that there's a lot of magic to it. But really, if you take a step back, it's large-scale complex litigation that has an additional procedural overlay. Right? We were joking a little bit before about, the federal court, it's, Section 33.
It's a lot of
33. So it's all within one section really. But that's right. So Part A, if we're looking at the federal court, is what governs the class action framework. As we said, so you're right, Nat, there's only need to be one common issue of fact or law, not and law. There is the additional, so it's cumulative. You have to have all three. So you've got the 7 people, one common issue of fact or law, and you have to have claims that are, all group members have to have claims that arise out of the same, similar or related circumstances. So you're right, it's not a difficult hurdle. There will be some circumstances, I suppose it's really going to turn on how the claim is drafted, where those may not be met, and there is some case law around that, but there's not been many decisions for the exact reasons we've been discussing. You can see that on many cases that are relatively tightly confined, those criteria are not going to be burdensome. Claims are usually defined in a way that is an open class. So I suppose an interesting thing as well when you're considering that this is a claim that's being brought about your employees. Your employers are brought along regardless of whether they know about it or want to be involved at the first pass. There does become a time later for some further engagement. But certainly when they're commenced, it'll be defined as people who shared certain characteristics within a certain time frame. And so long as you meet that definition, you're in, right? So I suppose that's an interesting feature. The other one is once the case commences, it's really kind of off and running. And so there's not many. Obviously, there can be some strikeout type interlocutory issues at an early stage, but once the case is commenced, it can't be resolved without the approval of the court. And so settlements must be approved by the court. And the reason for that is because, as you mentioned, Nat, there's this supervisory role that the court is expected to play and is required to play. And so they have to look at whether a proposed settlement is going to be, just and reasonable, just and fair for the actual group members. There's also some, I suppose, tensions that may arise in the employee context because, probably because of this protective role of the group members and that the court is acting in their best interest at all times. And it varies a bit between each court, but there are restrictions on how you can engage with group members once the claim's been commenced and they are a group member. And so, courts don't look lightly on those types of engagements with group members. And so companies have to be really careful, and lawyers, that they're not overstepping when they've got people who are perhaps still current employees. It can be quite difficult.
Yeah, it's incredibly, you can see how that might work if you're dealing with shareholders or where that relationship doesn't have a BAU aspect to it. And I know there's some carve-outs in the practice note, but it, from what I understand, it essentially brings in the plaintiff law firm to any communications around the issue, which is super complex when it comes to, remediating underpayments or, other individual employee matters, which may touch on this.
It's incredible. And I just want to punctuate that point because it's such an important one. As you said, Lucy, that BAU relationship is literally the employer and employee turning up to work every day. And the communication prohibition is such that if, for example, the claim is in relation to an underpayment matter and you want to just remediate your employees, there's all this rigour now in relation to how you do that. And we haven't spoken about the often reality that there will be parallel proceedings between the regulator, the Fair Work Ombudsman, or an individual employee who's bringing their own claim related but not as part of the group, and how you just practically navigate those things. So,
and the funny thing is because of what I understand, Mel, correct me, about the opt-out system, they could be pursuing an individual claim, but they are a part of the group because they haven't opted out.
And that's right. And that was what I suppose alluded to earlier, is that although you're in at the start, if you're caught by that kind of very broad, often definition, there will become a time later in the proceedings, usually around the time of a mediation discussion, which always happens, where there's a chance for group members to say, I do want to participate, so they then opt in, or they can opt out if they choose not to participate, for example, to pursue their own claim, or they just may not want to be involved at all. But that process is usually quite late. It's not set in stone. It can, with agreement of the parties and obviously the oversight of the court, occur at different times. But if I'm looking at our experience and the history of class actions, it's usually quite late in the proceedings.
That's an interesting and a big contrast for our quick and dirty matters that we do in our team. But how long do these proceedings usually go? Is that years into the process?
Well, it's absolutely years. And so if I'm looking at just generally the data on class action, and I'll talk about settlements because it's usually settlements, but let's talk about, I suppose, broadly resolution. It's taking 3 to 5 years, and if probably closer to the 5-year mark, and that's a whole range of factors. That's because there's tensions with multiple or parallel proceedings. It can be that the claim is not in a state yet that's ready to be, I suppose a defence is ready to be put on, and so there's some questions around the pleadings or other interlocutory early steps. It can be just waiting your turn in the court. It can be that the evidence is incredibly complex in these cases, so it just takes parties months and months actually to be able to put on their evidence. And so once you just start adding those things together, it's a very long timeline.
Yeah, it is.
And you can understand that parties are often not wanting to have discussions too early because the definition of the claim may not be sound, or obviously I'm thinking of it from a defence perspective, but you're giving discovery as a relatively early step in the proceedings. It's not always strategically the best move to sit down once you've just given over your discovery, because what we have seen when that does occur is that there tends to be a cherry picking of certain, offhand statements or what I call the bad documents, and the defendant side doesn't yet have any evidence on to kind of address those issues. So you're not really coming to the mediation with everyone putting their best foot forward. And so that's also why they tend to occur a bit later, once everyone's had a chance to reformulate the claims, have all your evidence on, so everyone at least is coming together with a clear picture of the landscape of the risks.
Yes.
But again, that does mean that we're talking about years and years and years before the claims are being resolved.
And Mel, even once the claims have been resolved by the court on those issues of fact and or law, that won't necessarily determine what it means for every single group member.
No.
Yeah.
And so then there's this complicated process, which is a matter between the parties to figure out, okay, well, what does that mean for you, Mel, and you, Lucy, and me, Nat, who has not been paid properly or worked on this day or, was exposed
form of
to
discrimination and
sexual harassment
the question of loss as well is super individualised.
And I suppose that is one difference from the class action to, I suppose, other types of litigation, which is really the class action will resolve or aims to resolve issues that are common to the group. And obviously there's a lead plaintiff or applicant,
Yes.
and it will resolve their individual claim. But that's right, we're talking about then, well, what's happening with the rest of the class? And so even if you get to the point of a judgment or a settlement, there is then the process of working out, okay, well, what about everyone else? And in certain cases, that can be easier. We talked a bit about shareholder. That becomes a bit more mathematical. But when we're looking at our products cases or really complex employee situations, some of those calculations can be quite difficult and then therefore take time, so more time before the group members are seeing any kind of redress for the issues that they've been litigating.
And perhaps allow me to proselytise a little bit about this, but it just, in a system where there is so much activity and there is genuine desire from an employer to do the right thing by its employees. There's been an error. Let's say there's admittedly an error in relation to the way wages have been administered or breaks have been provided or whatever it is. There is a disincentive or at the very least, very difficult hurdles that need to be jumped over in order to make that right for its people, for employees and sort of move forward. And so it just does make me wonder, and I want to quiz you about settlement and how that works, because there have been certain members of the judiciary, courts have been quite critical of proposed settlement terms because it doesn't provide the class with terms that are fair and just and reasonable in the circumstances. So again, let's just take the example of an underpayment claim. If an employee has been properly underpaid, let's say $10,000 over a 6-year period, and the employer wants to make that good, there is, as you've described, this process about being able to communicate with employees that needs to occur with the approval of certainly the plaintiff lawyers in relation to that. But then there's a clip of the ticket. So the employee ultimately is not getting their full entitlement that they would have been because money goes elsewhere. So tell us about that, and
and courts have been interventionists in the past and failed to approve settlements in these circumstances.
So go back, try again. Look, it's a really tricky area, and as I say, there's been so much discussion around what are the right outcomes here for all of the parties involved. If I put my plaintiff's hat on, they would say that, or plaintiffs and funders, so promoters' hat on, the argument is, I suppose, falls into an access to justice bucket, which is, if not for us, many of these claims would not be brought. Individual people don't have the resources necessarily to be able to pursue these issues. Let's come back and talk about whether that's right in an employment context. But for example, if I'm a shareholder or if I'm someone who's suffered a personal injury or, it may be too difficult to be able to take on a big company or to say, I want, I've lost $1 per share over this period, can I have that back? And so the argument goes that if not for the class action mechanism, many of those, what I'll call individual non-economic claims, are not going to get off the ground. And so
that
the system
follows, sorry to interject, that's clearly coming through in the recent changes we've seen in the Human Rights Commission Act, where they specifically brought in a form of representative proceedings.
And so that's the one side. The other side of that is, well, sure, but there needs to be balance. And so there have been, in the shareholder context, even recently, there's been a few cases where there's been about like a 50-50 split, right, in terms of what goes back to group members versus what goes to promoters. I think the key thing here is there is perhaps a mechanism for some of these claims to be redressed, but also it's a bit different when we're talking about people's employment, right, and then their wages or part of their wages or their entitlements. And again, the argument probably still goes from the promoter's side that, the employer has done something wrong and they're not addressing it either quickly or in a fulsome way.
It seems perverse, doesn't it? Where if you could conceivably have an employer wanting to rectify a payroll issue or settle a dispute, but this if you have one of these class actions intervening, it can have the practical impact of.
And it's the regulator is prosecuting almost exactly the same case over the same time period.
You see, there's already something on foot. So there is a mechanism for employees to have this issue assessed and redressed if there has been some wrongdoing there. I'm not sure what the current timeframes are with the processes through the regulator, but are they? That's a question for you. Are they the same kind of timeframes as? Okay,
once you're into into large claims, it's similar.
But I mean, this is the issue that exists, right? And that's not just for employment claims; it's for all types of claims, which is this constant tension between. Is it better that group members get something back if otherwise they would have had nothing back? And the firms and the funders are obviously they're running a business. They take on many cases for social justice reasons as well. But, it's a business and so they're on risk. And so the argument goes, well, if I'm on risk and I'm funding the proceeding, then I should get a return for that risk. But it's about the balance. So we were talking about potential reforms earlier. And so one reform that had been proposed many years ago now was that there kind of be a cap at 30% on returns to what I call the promoters side. That received a lot of criticism.
Yes.
And also a lot of discussion of, well, then that is perhaps going to lead to the bigger, more remunerative economic type claims being pursued and perhaps some of these other smaller types of claims not pursued because it's just not going to stack up in terms of the business and the economics of it. So it is a real tension. And I don't think anyone has the answers. Courts have this role, as you say. There has been a lot of scrutiny.
Yes.
Sometimes they'll knock things back and say, try again, or they will make some adjustments. But it is an imperfect system.
It is, yeah. It's a busy space.
It's a busy space.
It is a busy space. Just this year, let me give you a statistic because I brought some statistics with me. So we were talking about the fastest growing. So since January 2025, so January last year, there's been 31 just underpayment claims filed. Now, as I mentioned, that's a little bit skewed because kind of 19 related to this, talk about the junior doctors' underpayments. But this year, it has been off to a slower start in terms of class actions being filed. But I think as of last week or this week, there's been 9 that have been filed, but 3 of those are underpayments, right? So there's only one of them as a shareholder, but 3 of them are underpayment. And I'm just looking. It's interesting. I don't think this is a trend that's going to change. And as to your point, Nat, earlier, we've got some doctors, we've got a lot of retail in there as well. And so, again, we're talking about types of companies that have thousands upon thousands of employees. That's very hard to keep records in relation to, it's very challenging. But given where we started the conversation is that it's a really risky area because if you've got employees, there's potentially a mechanism for an employee-related class action.
And I just want to pick up very briefly on that settlement point and the court's supervision in relation to that and approval in relation to that. So it requires a great deal of thought and precision in relation to how settlements are structured and the preparation for mediation in the lead up to that. You cannot underdo that, I think, because, we were talking about the threshold to bringing a claim is just that common, relatively low common issue of fact or law. Once you're in. But a settlement needs to deal with the entire group. And that's where we, start to talk about either those fictions or, how do you apply this to make some assumptions about different groups and different people. So there's a great deal of sort of sophistication and thought required for that. And the court will not and has not approved some cases where that hasn't resulted in a just outcome for class members. So one that comes to mind for me is Justice Murphy in relation to the Woolworths underpayment claim, which of course ultimately went all the way through to trial. Now that was a proceeding where there were 4 parties effectively, or cases being case managed together. So there were a class action proceeding, a regulatory proceeding brought by the Fair Work Ombudsman, and then Coles in relation to similar proceedings where there was commonality of issues. Now, Justice Murphy refused to approve settlement in that case because it resulted in costs being paid to the plaintiff law firm, relatively modest costs being provided to the lead plaintiff and one of the other lead applicants in that proceeding, and nothing else to the group members. And part of the discussion was, well, okay, this is okay in the circumstances because the regulatory proceeding is going to pick up everyone else, but there was a slightly different time frame and a couple of arguments that were advanced in the class action which weren't advanced in the Fair Work Ombudsman litigation. So I raised this just to make the point about what we were describing for those listening in who kind of want to do the right thing by their people, who want to pay people, want to move things forward, at the very least just sort of move on, quite frankly, from this. It is a really difficult thing. Now, there is a couple of things that you can sort of know when this is coming. It's not, I know there's a low bar to entry, but a couple of things that I've seen, for example, one, they'll advertise for group members. So you can literally, some of the plaintiff firms will have a web page, let us know if you've suffered this injustice or you've been employed by this particular employer during this particular time. So that gives you a good heads up in relation to things. One thing I've also seen is there'll be a request for employee records under the Fair Work Act, and it will have a uniform form and it will be signed by one of the plaintiff firms saying, we act for these 6 or 7 employees, please provide records to us as you're required to do within a certain date. So there's certain things that you can sort of perhaps tell when this is coming, but
that is interesting, Nat. And it seems to be that often these proceedings sort of piggyback on regulatory proceedings, which we've talked about, or individual claims, say for an underpayment, then it's then magnified into a class. So they're definitely sort of things to be watching. I am interested to hear from you, Nat and Mal, about mitigation strategies. So what can employers be doing to put themselves in the best position if a claim comes along, or to fend them off in the first place? Maybe start with you from the employment perspective, Nat.
Call us and
What's
call
the
Mel.
solution? I think it's just,
Well, look, I mean, I don't want to sound trite in saying this, but there is nothing like making sure that the house is in order. I think it's also being very mindful in relation to communication with employees. If you are remediating, do that quite quickly. I think if there has been an underpayment and you communicate that, get the money into the hands of employers as quickly as possible. So there's probably less motivation for from the business model to pursue it as a claim.
Governance and early detection. So the quicker you can detect, and comes with that is getting reported up to the board oversight, all those factors. But from your perspective, Mel,
I totally agree with all of that, because the last thing you want to be the prompt for, oh no, we've got an issue, is seeing an ad on a plaintiff's website or seeing a discussion on some online forum, right? You want to be the one who detects the issue so that, as you say, you can move quickly to redress it. And as we've discussed, I think it has become clear that the challenges arise once a class action is commenced, because you do, for the most part, kind of enter this process, which is quite hard to exit out of. So really the goal is that you don't get there. If you can identify the issue, remediate it, it doesn't remove the risk of a class action. We have seen some instances where a company has remediated the issue, not just in an employment context, in other contexts as well, where then there's still a class action investigation that we see pop up, and it's the question is, were you compensated fully, or is there still a gap, or it's insufficient, or it's been improperly calculated? So it doesn't remove the risk, but it does certainly mitigate it, because, as you say, if part of the claim value, I suppose, has been eroded, or the issue's been addressed already by the employer, there's less work, I suppose, for the class action to do. I agree with the getting your house in order. Importantly, what we often see once we're called in, right? So it's better that you're called in and that then we're not needed. Because once we're called in, the things that we do tend to see, which are hurdles that need to be overcome, are where we see that some issues have been detected or at least flagged for further investigation. And there's a record of that.
Yeah.
And then either they haven't been or they haven't been quickly enough. Unfortunately, that becomes a roadmap for some kind of, allegation of wrongdoing. The other trap we often see is, and I suppose I encourage everyone to just do a little refresher on, is everyone clear about privilege? I suppose this is what the litigators always say when they come in. But when it applies, when it absolutely doesn't apply. And so we see more problems on the when it doesn't apply, where, privilege is not a magic wand. You put it on a document, it doesn't mean it is. And so sometimes we see that there's just communications being created in a not a controlled or thought through way. I'm not saying about over curating things. I'm just saying, in the heat of the moment, people not thinking about documents that they're creating, and they're labelled as privilege, and people might be making hindsight recollections or sorry, I should say like kind of hindsight opinions, not recollections, or just talking about things after the fact.
Commissioning reports for multiple purposes.
That are just unhelpful, right? And we see that a lot come up in cases where, including a couple of the cases recently that have favoured the plaintiffs in a different context, is that those types of documents are always seized upon, right? And there's often much made of them that's beyond what actually passed in the moment. But that can be one of the most difficult things to defend, is when people are not thinking about the documents they're creating, not thinking about whether something is in fact privileged or not, and just avoiding making, I suppose, after the fact pronouncements about things. And
I do sympathise for our clients though, because often it's in a crisis scenario. They've brought in all the different disciplines, comms, and where it involves your employees, that they're trying to do the right thing by their employees. That's for the primary objective. But we do see there's recent case law about this where it sort of unwinds then in later proceedings.
Yeah, that's right. And it's just, as I say, it's just becomes fodder or noise that you then have to address if you are facing a claim to try and explain away these things. And I think that's what most organisations are grappling with these days, with especially Teams, or if people are using Slack, instant messages are documents that get caught up in a discovery. They are documents. Text messages can be documents. So just a reminder, we call it kind of just careful or sensible communications, right? And just remembering that the old thing that we were always taught is that you don't put something in writing that you wouldn't be happy to see on the front page of the paper. There's, the only other, I suppose, practical tip, and it's not a mitigation one, because as I say, when we're called in, it's more about trying to put the best foot forward and kind of litigation readiness. But the only other tip I would have is just also knowing where your documents are. And because sometimes if you are faced with a claim, you want to be able to move quickly and collate things, and it sounds very straightforward, but in large organisations, or where we're dealing with claims that span many years across multiple thousands of employees, it's not as simple as it sounds. So I think doing some of those housekeeping things early, checking your systems and processes, doing regular kind of check-ins, and of course following up, are kind of really, that's good corporate governance anyway, but those things will then put you, I think, in good stead for any issues that do arise.
Oh, well, we could talk all day. It's so fascinating, and thank you so much for joining. We love getting to work
Thank you for having
with
me.
you too, with you guys. And thanks to our listeners for tuning in. As always, we welcome your feedback and any suggestions for episodes. You can contact us, so our details, or by the email address insideemployment@hsfkramer.com. Thanks for joining. Thanks, Mel and Nat.